This program is brought to you by Emory University.
All right, good morning, everyone. We're going to go ahead and get started. So again, good morning. Thank you all so much for being here with us today on this gorgeous Thursday morning. My name is Rashmi Bora, and I am the editor-in-chief of the Emory Law Journal. It is my pleasure to join the editorial board of ELJ and welcoming you all to the 2020 Randolph William Thrower Symposium. We are truly delighted to have so many students, professors, and practitioners here with us today to honor the life and legacy of Randolph Thrower and to join us in a discussion that is sure to be timely, informative, and engaging. The Emory Law Journal has hosted the annual Thrower Symposium since 1995. This event bears the name of a highly distinguished Emory Law alumnus, Randolph Thrower. Mr. Thrower was a partner at Sutherland, Asbill, and Brennan and was commissioner of the IRS from 1969 to 1971. After graduating from law school in 1936, Mr. Thrower served in the Marine Corps during World War II and returned to private practice after the war. Among his many accomplishments, Mr. Thrower served on the ABA's Commission on Women in the Profession, was president of the Atlanta Legal Aid Society, and was chair of the Georgia State Bar Committee on the Involvement of Women and Minorities in the Profession. Mr. Thrower was also one of the founders and the first president of the Court of Federal Claims Bar Association, and he was a founding trustee of the Lawyers Committee for Civil Rights Under Law. Today's symposium is entitled Election Law in a Changing Political Landscape. The right to cast a vote in a fair election is one of the most recognizable pillars of a democratic society, and it is a right that we have had to fight for over and over again. From the familiar slogan of taxation without representation during the Revolutionary War, to the suffragette movement, to the marches of the Civil Rights Movement and the passage of the Voting Rights Act. For a while, some of us might have thought that those fights were behind us. But once again, there are questions about whether the right to vote and whether our electoral process in general is still trusted and intact. This year's symposium is a response to the increasingly contentious local, state, and federal elections that have taken place over the last few years. In the last several elections, there have been reports from across the country that certain communities have been subject to voter suppression, that some campaigns were violating campaign finance laws, and that voter ID laws in several states were enacted as a barrier to certain groups of people being able to vote. In 2018, the state of Georgia found itself in national headlines as the center of a contentious and contested gubernatorial election. The election was plagued with allegations of vote tampering, gerrymandering, discounted absentee ballots, broken voting machines, and widespread voter suppression, and some of those disputes are still ongoing. We are now mere months away from the highly anticipated 2020 presidential election, which kicked off in spectacular fashion with the Iowa primary. And as residents of a battleground state, the students of the Emory Law Journal felt that the time was ripe for us to engage in a thorough and challenging conversation about the state of election law in this state and in this country. We sincerely hope that each of you finds this symposium to be informative and thought-provoking, and we encourage you to engage with our speakers, as today is only the beginning of this conversation. The ideas and debates discussed today will be memorialized in Volume 70 of the Emory Law Journal, and that issue will benefit from your contributions. I want to now take a moment to thank the people who have made today's symposium possible. First, thank you to the Thrower family for your remarkable generosity. This symposium is only possible because of you, and it's a testament to your support that we have been able to hold Thrower Symposium for the last several decades. This event benefits not only the Emory Law Journal, but also the law school and the entire Atlanta community. So thank you so much for your continued support. Thank you also to the Thrower Committee for helping shape the vision of this year's symposium and for supporting the journal throughout the planning process. In addition, thank you to the Emory Law Faculty and Administration for providing invaluable guidance and counsel. We specifically thank our faculty advisors, Professor Pardo and Professor Dinner, and the Emory Law faculty participating in today's symposium, including Professor Smith and Professor Volek and Professor Dinner, who are serving as moderators for today's panels. Finally, I want to recognize members of the Emory Law Journal. First, thank you to Alexandra Landgraf and Alex Capelli, who are our symposium editors. They have gone above and beyond in helping plan today's symposium. In addition, thank you to all of the 2Ls who are members of the journal who have been working hard over the last several days and will continue working throughout the day to make sure that this symposium is a success. Our 2L students are the future of the Emory Law Journal, and I have absolute confidence that the symposium and the next volume are in good hands with them. And last, but certainly not least, thank you to Will Carlucci, our executive symposium editor, for volume 69 of the Emory Law Journal. From coming up with the vision of today's symposium to executing all of the details of the symposium, Will has spent the last year making sure that today's symposium is a success. And we are all so grateful to Will for his time and dedication to this symposium. It is now my pleasure to introduce and welcome to the stage William Carlucci.
Good morning, and thank you all for coming. As Rashmi said, I am William Carlucci, the Executive Symposium Editor for Volume 69 of the Emory Law Journal. I'd just like to briefly extend a few thank yous, namely to the Thrower Committee. Without your guidance, support, and contributions, the symposium would not be possible. So I greatly appreciate all of your assistance in helping to put on this symposium. Next, I would also like to thank the 2Ls who have over the past few days been working to make sure that all of the plans that I have put in place are executed and carried out, and for that I'm thankful. I'd also like to thank Alex Landgraf and Alex Capelli, who have assisted me throughout the entire process. They've made sure that all of my visions for this symposium have been a success, and I'm sure that they will continue to do so throughout the day. And last but not least, I would like to thank Rhonda Earmans, Danae Duran, and Amy Marcelano, who have worked to help with getting the programs together, organizing the online registration, and all of the wonderful operations behind the scenes today. So thank you, thank all of you for all of your contributions and support to the symposium. That being said, I would like to now move on to the actual body of the symposium. I would like to introduce our keynote speaker today, Emmett Bondurant, who is a partner at Bondurant, Mixon, and Elmore here in Atlanta. Emmett Bondurant is a nationally recognized trial lawyer with more than 50 years of experience representing both plaintiffs and defendants. He is a fellow of the American College of Trial Lawyers and the American Academy of Appellate Lawyers, and has been recognized by the National Law Journal as one of the top 10 trial lawyers in the United States. As the 2010 Lawyer of the Year for Antitrust and Bet the Company litigation by Best Lawyers in America, a leading antitrust lawyer by Chambers USA, the 2012 Lawyer of the Year for Arbitration and First Amendment litigation by Best Lawyers in America, and listed by the Atlanta Magazine as among the top 10 Georgia super lawyers. Emmett's career has included a strong commitment to community service and pro bono litigation, including death penalty, habeas corpus, reapportionment, and other civil rights and constitutional cases, including representation of Guantanamo detainees. He has served as president and a director of the Atlanta Legal Aid Society, president of the University of Georgia Law School Alumni Association, chairman and member of the board of the Georgia Resource Center, a trustee of the American Inns of Court Foundation, a member of the board of Gideon's Promise, and is currently a member of the National Governing Board of Common Cause. He also served as chair of the Atlanta Charter Commission, a successful 2-year effort to completely rewrite the 100-year-old Atlanta City Charter. So without further ado, I welcome to the stage Mr. Emmet Bondurant.
Thank you, Will, for that generous introduction. Before I begin, let me tell a personal story that makes this particularly meaningful for me. I am particularly honored to be asked to give the Thrower Lecture because Randolph Thrower was not only one of Atlanta's finest lawyers, he was the lead counsel in a case involving voting rights in which I was the youngest lawyer on the team in 1966, that went to the Supreme Court challenging the question of whether or not Georgia's 1824 constitutional provision that required that the legislature elect the governor in the event no one received a majority in the general election was constitutional. That provision, as you know, is essentially copied from the U.S. Constitution. But the outcome of the case decided whether or not Lester Maddox would be the governor of Georgia, because at that time, the Georgia General Assembly was dominated by the rural General Assembly, most of whom were Democrats. The Republican Party at that time could hold its convention in an election booth, in a telephone booth. And we had an election in which the candidates were, in the general election, Bo Callaway, a Republican nominee, the Callaway fortune, and later in Nixon's cabinet is Secretary of the Army, and Lester Maddox, the owner of the Pickwick restaurant. Well, on the eve of that election, the senior partner of my then law firm, Smith Kilpatrick, came in and said, "I think you know something about elections. This election is going to end up with no one getting a majority. The General Assembly will elect. What can you do about it?" So I stayed up all night, drafted a complaint, and was invited to Sutherland, Asbel, and Brennan to meet with Randolph Thrower, who was a senior partner at Sutherland and a leading Republican lawyer in the state. And together, we put together a complaint challenging that procedure. A three-judge court heard the case. A week later, ruled the Georgia constitutional provision unconstitutional. But unfortunately, the Supreme Court took the case on an expedited basis, and in 32 days reversed. We went from an election to a final decision in the Supreme Court on oral argument. And in a 5-4 opinion, which is a forecast of Rucho v. Common Cause, the court ruled that there was nothing in the federal Constitution that told Georgia how to elect a governor. In that process, Randolph was the lead counsel. On the Thanksgiving Eve, I was at Sutherland working with Randolph Thrower, who was obviously much my senior, at 2 in the morning, putting the finishing touches on the brief to be taken by an associate at Sutherland to Washington on Thanksgiving Day to be printed and filed in the Supreme Court the next day. So Randolph has a particular tie to these issues. And as a real lawyer, a working lawyer, not a senior partner supervising from above at long distance, but working in the trenches in trying to bring about fair elections in the state. So I am particularly honored to be giving a Thrower lecture on behalf of someone that I admire greatly and was one of the country's finest lawyers and finest people. Let me turn now to Rucho v. Common Cause. Let me give you the usual caveat, which is, I do not claim to be unbiased. I have a point of view. In Rucho v. Common Cause, the Supreme Court had an opportunity to create a more perfect union. It chose instead to deal a body blow to the democratic process when it held in a 5-4 party line vote that partisan gerrymandering is non-justiciable political question that is beyond the competence and the jurisdiction of the federal courts. The ruling overturned 30 years of Supreme Court precedent that had held that partisan gerrymandering is justiciable, although the court had not completely settled on a theory under which it could be attacked. The court had repeatedly held it to be justiciable. The majority opinion was written by Chief Justice Roberts, who accepted the fact that partisan gerrymandering is incompatible with democratic principles. And he said it also leads to results that reasonably seem to be unfair. But he said that does not mean that it is within the competence of the jurisdiction of the federal court. He held that it was not justiciable because the Constitution provides no judicially manageable standards for distinguishing between permissible and impermissible partisan gerrymandering. No standards for distinguishing between acceptable levels of gerrymandering and those which are excessive. That is an echo of the position taken by Justice Scalia in Veith v. Jubilee Era in 2004, but rejected by a majority of the court. But the court did not stop there. Despite having ruled that federal courts have no jurisdiction of partisan gerrymandering claims, the majority actually endorsed the constitutionality of partisan gerrymandering. Chief Justice Roberts said, and I quote, "Voters cannot ask for the elimination of partisanship in redistricting." He said, quote, "While it is illegal for a jurisdiction to depart from one person, one vote rule or engage in racial discrimination in redistricting, it is not illegal for a jurisdiction to engage in constitutional partisan gerrymandering." He went on to say, "Legislatures have the authority to engage in a certain degree of partisan gerrymandering, and that an intent to achieve a partisan advantage and entrench the majority's hold on political power is permissible and does not become constitutionally impermissible when that permissible intent predominates." Let me stop there and say the Supreme Court has never held in a litigated case that partisan gerrymandering is unconstitutional. The only authority cited by Chief Justice Roberts in his opinion was dicta buried in Hunt versus Cromartie and the racial gerrymandering cases in which the Supreme Court had allowed states accused of racial gerrymandering to rebut the plaintiff's prima facie case, which required the plaintiff prove that race was not only a material factor, it was the predominant factor in gerrymandering. In those cases, the court said states may rebut that by proving that they were not trying to discriminate on the basis of race, they were trying to discriminate on the basis of politics. And the fact that a majority of black voters happened also to be Democratic voters did not make that intent predominant. But there is a difference between allowing a defense and ruling that the defense is constitutional. But buried in those cases by conservative justices was essentially the poison pill. They called it constitutional gerrymandering. But the court had never ruled on that issue. Rucho reached the court at a time when 4 federal district, 3-judge district courts had held unconstitutional partisan gerrymandering of congressional districts in North Carolina, in Maryland, in Ohio, and in Michigan. The decisions were remarkably consistent in that at least 3 of the 4 cases ruled partisan gerrymandering invalid under the First Amendment as a form of viewpoint discrimination, under the Equal Protection Clause, for obvious reason that it discriminated without rational basis between voters based on their political affiliations, and under Article 1, Section 2, and Article 1, Section 4 of the Constitution. In the Maryland case, the district court relied exclusively on the First Amendment and viewpoint discrimination. So it reaches the Supreme Court when the lower courts had fairly thoroughly dealt with the issue. Moreover, the Pennsylvania Supreme Court, relying on their own state constitution, had ruled the partisan gerrymander of its congressional districts unconstitutional under a 1777 provision of the state constitution that required fair elections. Justice Kagan pointed out the irony of the majority's position in her dissent. She said that the majority is throwing up its hands and missing something that is right under its nose. What it says can't be done has been done. Federal courts across the country have largely converged on a standard for adjudicating partisan gerrymandering claims, striking down both Democratic and Republican redistricting plans in the process. The Rucho decision, coming on the eve of the 2020 census, sends a wrong message to the major political parties. It has told the major political parties that anything goes in redistricting, and that they have a green light to adopt even more extreme partisan gerrymanders of both congressional and state legislative districts in the redistricting which will follow the census in 2021. Better scholars than I have described the Rucho opinion as, quote, not an easy case to take as doctrine. Chief Justice Roberts' opinion, Guy Charles has written, is more of a debater's brief than a judicial opinion, an amalgam of misdirections, distortions, and less than pellucid thinking. The majority opinion is, to put it kindly, a maze of contradictions. How can a court say that partisan gerrymandering is incompatible with democratic principles, as the court said in Rucho, and as it previously said in the Arizona State Legislature case, if there are no manageable standards in the Constitution that are sufficient to enable a court to make that judgment? And if, as the majority held in Rucho, the constitutionality of partisan gerrymandering is a political question that is beyond the competence and the jurisdiction of the federal courts, how can Chief Justice Roberts say that partisan gerrymandering is not illegal and that a jurisdiction may engage in constitutional partisan gerrymandering? Let me go back with a little bit of history. The Supreme Court has held partisan gerrymandering to be justiciable for well over 30 years. Although Chief Justice Roberts said in Yill that the prior cases, Vandermeer, Veith, and Lulac, had left the question unresolved, the fact is it was resolved in those cases. Vandermeer held that partisan gerrymandering claims were justiciable. A majority of the court in Veith held that they were justiciable. Justice Kennedy cast the key vote, disagreeing with the plurality by Justice Scalia, who would have declared them non-justiciable. And 3 other justices also concurred. And in Lulac, the Supreme Court said, in an opinion also written by Kennedy, we do not revisit the holding in Davis and Veith that the claims are justiciable. Moreover, in Veith, Justice Kennedy had an insight that frankly had been missed by most of the reapportionment community up to that point. He suggested that the prior cases have been brought under the Equal Protection Clause, and that in future cases, they would be wiser to be brought under the First Amendment. Because, as he explained, the First Amendment, they always involve the First Amendment interest of not burdening or penalizing citizens because of their participation in the electoral process, their voting history, their association with a political party, or their expression of political views. He went on to say, under general First Amendment principles, those burdens are unconstitutional, absent a compelling governmental interest. The Supreme Court had several opportunities subsequent to Davis, Veith, and Lulac to reconsider the question of justiciability. In 2015, a pro se case reached the Supreme Court called Shapiro against McManus. Shapiro was a voter in Maryland who challenged a Democratic gerrymander that had literally taken an axe to one of the two Republican congressional districts and divided it in half and submerged the Republican voters in districts in which they were certain to be outvoted. The district courts in that case had refused to convene a three-judge court on the basis that the claim was so frivolous that they didn't have to convene a court. The Fourth Circuit affirmed without opinion. The Supreme Court was unanimous in reversing, remarkably in an opinion written by Justice Scalia. No member of the Supreme Court argued in that case that the judgment should be affirmed because the issue was non-justiciable. Instead, Justice Scalia said that this appellant had alleged a violation of the First Amendment on a theory advocated by a member of this court on which the court has never ruled, and that whatever one may say about the claim, they were not passing on its merits, but they remanded it to the district court with instruction that it rule on the merits of Mr. Shapiro's First Amendment claim. That case later became Menesek against Lamone, which was decided with Rucho by the Supreme Court in a single opinion. The court had another opportunity to revisit the issue of justiciability in Gill v. Whitford. Gill was a case brought by Democratic voters in Wisconsin challenging the constitutionality of a Republican gerrymander of the Wisconsin legislature. The court's opinion was again unanimous. The court held that the lead plaintiff, Professor Whitford, did not have standing to challenge a statewide plan as a whole, but that four other plaintiffs had alleged an injury to their rights to vote, namely vote dilution, that should be heard and should be given an opportunity to prove. The reason Professor Whitford did not have standing was that he did not live in a district that had been gerrymandered. He lived in the People's Republic of Madison, which was overwhelmingly Democratic and was going to be Democratic no matter what happened. His theory of injury was that he and other Democratic voters in the state could not convert their statewide support for Democratic candidates in state legislative elections into a comparable number of seats, and that deprived them of the opportunity to enact Democratic legislation. The court at trial, he relied, and he was the only witness who testified, on partisan asymmetry metrics in the efficiency gap to measure the effect of that gerrymander has on the fortunes of political parties. The court unanimously held that he did not have standing. That was not an individual injury, and moreover, Democratic voters had no right to proportional representation in the state legislature. But in contrast, Professor Whitford, Chief Justice Roberts held that four other plaintiffs had alleged in their complaints that they lived in gerrymandered districts in which their votes had been diluted. He held that they had pleaded a particularized burden that was sufficient to give them standing under the Equal Protection Clause to challenge the constitutionality. He specifically held that vote dilution is a district-specific injury to voters who live in districts that have been packed or cracked. He explained that the harm to these voters, quote, arises from the particular composition of the voter's own district, which causes his vote, having been packed or cracked, to carry less weight than it would carry in another hypothetical district. These voters had not testified at trial and had not actually proved vote dilution. At least three justices of the court wanted to simply reverse and direct the dismissal of the case. But the majority, led by Chief Justice Roberts, refused. It instead remanded the case to the district court with instructions that the Democratic plaintiffs be given, who live in districts where Democrats like them have been packed or cracked, have an opportunity to prove their vote dilution claims. That is, that their votes would have carried, they carried less weight in the gerrymandered districts than they would have carried in districts that had not been gerrymandered. When the court held in Gill that the plaintiffs had standing, it necessarily held that their claims were justiciable. Scholars may or may not agree with this proposition, but I think it is correct. Chief Justice Roberts said in Gill, "We do not decide the justiciability question in this case," but he held that the four plaintiffs had alleged claims or had standing to assert claims. How can a plaintiff have standing to assert a claim that is not justiciable? Justiciability is a threshold question and an essential prerequisite without which a plaintiff cannot have standing to assert a claim within the Article III jurisdiction. While many would-be plaintiffs may or may not have standing, there are no plaintiffs who have standing to assert a non-justiciable claim. A finding of standing requires judicially manageable standards. You can't make it without them. Those standards must be sufficient to enable the court to determine four things: that the plaintiff has a cognizable legal right under the Constitution. Secondly, injury in fact, that the plaintiff has alleged an injury to himself, not to the body politic in general, as a result of that violation. Causation, that the injury which he alleges, in this case vote dilution, is fairly traceable to the challenged action, that is the gerrymander of the districts. And fourth, redressability, that the voter's injury, vote dilution, can be addressed by a court, as, for example, by an injunction that says stop diluting the plaintiff's vote. Without judicially manageable standards, the Chief Justice would have had no basis to rule that these plaintiffs had standing. He didn't make it up. He simply applied existing precedents. How then did he come to the conclusion in Rucho that the case was non-justiciable? The answer is he did not. What he did instead was change the subject from vote dilution to proportional representation. Instead of addressing the merits of the plaintiff's claims in Rucho, he said, quote, "Partisan gerrymandering claims rest on an instinct that groups with a certain level of political support should enjoy a commensurate level of political power and influence. Explicitly or implicitly, a districting map is alleged to be unconstitutional because it makes it too difficult for one party to translate statewide support into seats in the legislature, a norm that does not exist in our electoral system." He went on and said, "Partisan gerrymandering claims invariably sound in a desire for proportional representation, that plaintiffs inevitably ask that courts make their own political judgment about how much representation political parties deserve based on the votes of their supporters and to rearrange the challenged districts to achieve that end." Chief Justice Roberts conflated the objective of a partisan gerrymander with the injuries to the constitutional rights of voters caused by partisan gerrymandering. The objective of a partisan gerrymander is to give the majority party more than its fair share of seats, that is, disproportionate representation in the legislature. The injury, however, is not the denial of proportional representation. The injury is the means by which they accomplish their objective, which is by vote dilution. The remedy for a partisan gerrymander is not to ask a court to rearrange seats and reallocate political power based on statewide share of the seats of the Democratic vote, for example. As Chief Justice Roberts said, the remedy is simply an injunction, as in a racial gerrymander case, or as in one person, one vote case that says, stop discriminating based on political views, affiliation, and voting history. Chief Justice Kagan pointed out the hypocrisy of the majority opinion in her dissent. She said in her dissent, quote, "Everything in today's opinion assumes that these cases grew out of a desire for proportional representation or a fair share of political power. But that is not so. The plaintiffs ask only that the courts bar politicians from entrenching themselves in power by diluting the votes of their rivals' supporters." The logic of that is inescapable. As she pointed out in her dissent, partisan gerrymanders operate by vote dilution. As Justice Stevens pointed out in Veith, they always involve the drawing of district lines to maximize the voting strength of the dominant political faction and to minimize the strength of its opponents. How? By diluting their votes. Vote dilution in federal elections for members of Congress is prohibited by Article 1, Section 2 of the Constitution. In Westbury v. Sanders, the Supreme Court held that the hold that legislatures may draw congressional districts to give some voters a greater voice in choosing congressmen would violate Article 1, Section 2 of the Constitution and, quote, defeat the great compromise. Vote dilution in federal elections is also a violation of the Elections Clause, which is a limited delegation to the states of political power to adopt procedural rules for elections, which the Supreme Court in prior cases, not cited by Chief Justice Roberts, has held does not include the power to dictate electoral outcomes or favor or disfavor a class of candidates. What does a partisan gerrymander do but dictate the outcome of elections in specific districts by diluting the votes, cracking and packing, and by favoring particular candidates' selection in particular district. Vote dilution is also prohibited by the First Amendment. In Anderson against Celebresi, the court held that the right of qualified voters, regardless of their political persuasion, to cast their ballots effectively ranks among our most precious freedoms, and invalidated Ohio's ballot access laws that made it more difficult for John Anderson and his independent campaign to qualify at an earlier period than the national political parties. Vote dilution is it's also been held to be a violation of the Equal Protection Clause. Reynolds against Sims, the Supreme Court held, diluting the weight of voters because of place of residence impairs basic constitutional rights under the 14th Amendment. And in Gray v. Sanders, the Georgia County Unit case, the court held, once the class of voters is chosen, as in a districting system, there is no constitutional way in which equality of voting power may be evaded. If this seems elementary constitutional law, it is, but it was not followed in Rucho. The Supreme Court has held in the racial gerrymandering case, particularly in Shaw against Reno, Justice O'Connor said that racial gerrymanders are antithetical to our system of representative democracy. But partisan gerrymanders are as antithetical, if not more so. Both gerrymanders, racial and partisan, send the same pernicious message to elected officials. Again, in Justice O'Connor's words, when a district is created solely to effectuate the perceived common interests of some group, whether that group is a racial group or is Democratic or Republican, elected officials are more likely to believe that their primary obligation is to represent only the members of that group rather than the constituency as a whole. But partisan gerrymanders have an effect that racial gerrymanders do not. Partisan gerrymanders make the party primaries in which only party members or party devotees vote the determinative election. They are a replication of the Democratic white primaries, in which the white primary was determinative of the outcome of the election. Black voters under the Democratic white primaries could vote in the general elections, one person, one vote. They were not prohibited, but the game was over before the general election was held. The outcome was determined in the primary election. So partisan gerrymanders make the outcome of the primary determinative. And if you have any doubt about that, you live in the most gerrymandered state in the United States, Georgia. In the 2016 elections, and I'm doing this from memory, 80% of Georgia's House seats in the state legislature and 80% of Georgia's Senate seats in the legislature had no general election opponent. In 2014, 7 of the 14 congressional districts in Georgia had no general election opponent. Why was that? Because the people who would run for office knew that the outcome in those elections was dictated by the gerrymanders of the district. And it was not worth a filing fee for a Democrat, for a Republican, for example, to run in the 5th congressional district against John Lewis, or in the 4th congressional district. And conversely, it was not worth the filing fee for a Democrat to run in one of the rural congressional districts. So partisan gerrymanders have really made the general election an illusion. It does not matter if you live in a gerrymandered district, whether you go vote in a general election for a member of Congress or the state legislature, because the outcome has been determined in advance, your vote has been diluted, and the outcome is certain that it's going to be either a Republican district or a Democratic district. Over time, that will dissipate with changes in demography. But whoever thought that it was okay to rig the outcome of one election, even if it dissipates over the period of a decade, or in part? By changing the framing of the issue from vote dilution to partisan gerrymandering, Chief Justice Roberts made the outcome inevitable. If instead he had asked, instead of asking how much partisan gerrymandering is too much in terms of giving one party or the other too large a share of the seats, he had asked how much vote dilution is too much, he would be hard-pressed to find a case ever that says a little bit of vote dilution is perfectly okay, just like a little bit of racial discrimination is not okay. Moreover, there's another problem in the opinion. That is the elections clause, and this is particularly difficult. The elections clause, the court has held, was intended by the framers not as a grant of plenary power to what are called political entities, state legislatures and Congress, over congressional districting, but a limited delegation of the power to adopt procedural rules. The Republican appellants in Rucho argued that the elections clause, that through the elections clause, the framers set aside electoral issues involving the validity of congressional elections as questions only Congress can resolve. That was the argument. They tried to make that argument during the oral argument of the case. Paul Clement, who is a very able lawyer, started down that road. Justice Kagan cut him off and said, quote, "That ship has sailed." And that was the end of the argument. However, as with zombie economics, ships that have sailed can be resurrected by the Chief Justice. He said he did not agree with the appellant's arguments in two respects, in two areas: one person, one vote, and racial gerrymandering. In those two areas, he said, our cases have held that there is a role for the courts with respect to some issues that would arise. He said, however, that outside these two areas, to hold that legislators cannot take partisan interest into account in drawing districts would essentially countermand the framers' decision in the Elections Clause to entrust districting to political entities. The problem with that is the Supreme Court since 1932 has consistently held that the Elections Clause did not deprive the federal courts of jurisdiction over issues involving congressional districting. In Baker against Carr, the Supreme Court, citing three earlier cases, said that Smiley against Home, Koenig against Flynn, and Carroll against Becker from 1932 had, quote, settled the issue in favor of justiciability. None of those three cases involved the one person, one vote rule, nor did they involve issues of race or racial gerrymandering, nor did the decisions of the Supreme Court in Arizona State Legislature against Arizona Independent Redistricting Commission, in which the court, in a 5-4 opinion with Justice Kennedy as the swing vote, upheld the constitutionality of the power of the people of Arizona by referendum to take redistricting power away from the Republican legislature and put it in the hands of an independent redistricting commission. Nor was race or the one person, one vote rule involved in U.S. term limits against Thornton, which was the question of whether or not a state could impose term limits on federal officers contrary to the provisions of the Constitution, or in Cook v. Graylick, in which the issue was whether the people in a state could, by constitutional amendment, require that it be disclosed on the ballot that a particular candidate for federal office either was for or against term limits. And there are a series of other cases in which the Supreme Court has applied the Elections Clause and has explicitly rejected the argument that the Elections Clause represented a textual commitment by the Constitution of the issue to a coordinate branch of government. It rejected the argument. The issue was squarely presented in Westbury v. Sanders. The court held in a 6-3 vote that, quote, nothing in Article 1 supports the construction that would immunize state congressional apportionment laws which debase a citizen's right to vote from the power of the courts to protect constitutional rights of individuals from legislative action. The right to vote is too important in our free society to be stripped of judicial protection by such an interpretation of Article 1. There is nothing that says that holding was limited only to one person, one vote cases. Nevertheless, Chief Justice Roberts said in Rucho, the framers were aware of electoral redistricting problems and considered what to do about them. They settled on a characteristic approach, assigning the issue to state legislatures expressly checked and balanced by the federal Congress. At no point was there a suggestion by the framers that the federal courts had a role to play or that any indication that framers had ever heard of such a thing. He ignored the Supreme Court's own precedents. The Supreme Court had previously held, in cases which he did not cite, that the framers' primary solution to those potential electoral districting problems was not to deprive federal courts of jurisdiction, but to limit the authority of state legislatures over congressional elections to the adoption of procedural rules. The court specifically held in term limits against Thornton and repeated it in Cooks against Graylick that the framers understood the Elections Clause as a grant of authority to issue procedural regulations, not as a source of power to dictate electoral outcomes, to favor or disfavor a class of candidates, or evade other important constitutional restraints. The Chief Justice was equally mistaken when he says, at no point in the framing of the Constitution was there a suggestion that the federal courts had a role to play in the enforcement of the Elections Clause or anything else, nor was there any indication that the framers ever heard of courts doing such a thing. To the contrary, in the Federalist Papers, number 78, Alexander Hamilton emphasized that constitutional limitations, quote, can be preserved in no other way than through the courts, whose duty is to declare all acts contrary to the Constitution void. More specifically, ultra vires acts he addressed a little later in the same section of the Federalist Papers. He said, every act of a delegated authority contrary to the commission under which it is exercised is void. Moreover, in the ratification conventions, as the court pointed out in Westbury v. Sanders, court enforcement was discussed. In North Carolina, one of the delegates, John Steele, said that if Congress were to use its power in the Elections Clause, quote, to make laws inconsistent with the Constitution, independent judges will not uphold them. Thus, the enforcement of the Elections Clause, as with other provisions of the Constitution, before Marbury v. Madison, was contemplated by the framers, was discussed at the Federal Convention. Chief Justice said that the Constitution does not contain a fair districts election provision. Well, in a literal sense, that is absolutely true. But the Constitution contains two amendments that can be fairly characterized as fair district amendments. The First Amendment of the Constitution, which the Supreme Court held in West Virginia Board of Education against Bartlett, deprives any government official, high or petty, of authority to prescribe what shall be orthodox in politics, in nationalism, or religion. Moreover, in the First Amendment cases, the Supreme Court has repeatedly held that viewpoint discrimination is a presumptive violation of the First Amendment and is permissible with no ifs, ands, or buts, only if supported by a compelling state interest of paramount importance. Moreover, the court has held that the Equal Protection Clause of the 14th Amendment means, if anything, that government has a duty to govern impartially. A duty to govern impartially. What clearer violation of that duty could you have when the government gerrymanders districts to make sure that the majority party will win a majority of the seats and to confine the majority party to as few districts, the minority party to as few districts as possible? In Veith, the issue that really comes to light in Rucho was argued by Justice Scalia. Justice Scalia argued in Veith that the court should hold partisan gerrymandering claims unconstitutional because there were no judicially manageable standards from distinguishing between excessive partisan gerrymandering, which he, for the sake of argument at least, was prepared to admit was illegal and unconstitutional from what he called ordinary partisan gerrymandering. But he then said, there are no judicially manageable standards for drawing that line, hence the question is non-justiciable. Justice Kennedy, in his dissent that I quoted to you earlier, or in his concurring opinion in Veith, pointed to the First Amendment, as did Justice Stevens. Justice Scalia's rejoinder to that was, well, you can't apply the First Amendment to partisan gerrymandering because that would outlaw all consideration of political factors in redistricting. Justice Kennedy responded, he said, that is a misrepresentation of the First Amendment position. He said, quote, the inquiry is not whether political considerations were used, end quote, but how and why they were used. Were they used for a lawful or an unlawful purpose? Quote, the proper inquiry, he said, is whether political classifications were used to burden a group's representational rights. If a court were to find that a state imposed burdens or restrictions on groups or persons by reason of their views, there would likely be a First Amendment violation. In short, there is no partisan gerrymandering exception to the First Amendment. There is no support in the Constitution for Justice Scalia's position in Veith that, quote, segregating voters by political affiliation as long as one doesn't go too far is lawful, or that the Constitution permits, as the court said in the racial gerrymandering cases, constitutional political gerrymandering. Constitutional political gerrymandering is an oxymoron under our Constitution. Is an affront, is much an affront to the Constitution as is racial gerrymandering or religious gerrymandering or violations of the one person, one vote rule. One of the great debates among scholars was, and we certainly faced it as a tactile issue in Rucho, as to whether or not we should argue that only excessive partisan gerrymandering was unconstitutional. The rationale for that was that everybody in Veith, of every political persuasion, right and left, agreed that excessive partisan gerrymandering was unconstitutional. But that was a justiciability trap laid by Scalia in the Veith opinion, which he immediately acknowledged. He said that these concessions with which he was prepared to agree did not alter the reality that no judicial management standard existed for distinguishing between what he claimed were lawful political gerrymanders that segregated voters by their political affiliations from excessive partisan gerrymanders. Both Justice Kennedy and Justice Stevens in Veith pushed back against that. Kennedy said, in addition, that courts should be careful about assuming that partisan gerrymanders turns on whether something is excessive or not. He then gave two examples, an extreme partisan gerrymandering and a more subtle partisan gerrymander that involved only some of the districts. And he concluded both are equally culpable. Justice Stevens rejected the same argument in Veith. Nevertheless, those were the arguments that were accepted by Justice Roberts and by the majority in Veith, that there is such a thing as constitutional partisan gerrymandering, that there are no judicially manageable standards for distinguishing constitutional partisan gerrymandering from excessive partisan gerrymandering, that even though partisan gerrymandering is incompatible with democratic principles, courts are incapable of dealing with the issue. Where did that really leave us? I think it's fair to say that the increased polarization in the Senate in the confirmation of the federal judiciary on strictly ideological lines has carried over to the Supreme Court. If you look at the cases over the last 20 years, starting with Bush against Gore, you will see a consistent pattern in which election cases were decided by partisan votes along party lines, with very few exceptions, 5-4, all in favor of the party that appointed the justices in the majority. That was true of Bush v. Gore. That was true of Shelby County v. Holder. That is true of McCutcheon against the Federal Election Commission. That was true of the Arizona public financing case written by Chief Justice Roberts, and in which he said that this poor millionaire in Arizona might be deterred. His First Amendment right to spend money on his own election might be burdened if he knew that the state of Arizona was going to contribute to his opponent an equal amount of matching funds if he exceeded campaign finance limitations. And that poor Mr. McCutcheon's First Amendment rights were heavily burdened because he could only give to, I've forgotten whether it was 15 or 20 members of Congress. He could not give the max to all 435 members. Even though he couldn't vote for only the members, he could vote for only the members who lived in the district in which he lived. So where are we? I think it's fair to say that for the foreseeable future, the federal courts are closed to partisan gerrymandering claims. Moreover, I think it's fair to say with the shift in the composition of the court, independent redistricting commissions as to congressional districts are very much in jeopardy. In Arizona State Legislature versus Arizona Independent Redistricting Commission, the court by 5-4 vote upheld the power of the people of a state to exercise initiative and referendum to take the power of redistricting of congressional districts away from the legislature and put them in an independent district, in an independent commission. Chief Justice Roberts wrote the dissent, joined by 4 other Republican justices, in which he said, in 1787, legislature in Article 1, Section 4 meant legislature, that nobody had ever heard of initiative and referendum in which the people could take from the legislature its powers under their state constitutions and put them anywhere. That was not a reform that came into existence until the 1890s, particularly in the western states, and therefore the people of Arizona were depriving the Republican legislature of their constitutional right to gerrymander congressional districts, and that was unconstitutional. Justice Kennedy was the swing vote in that decision. Justice Kennedy is no longer there. So the future of even independent redistricting commissions in congressional elections is very much in doubt and will undoubtedly be challenged. A second challenge that is coming, you can kiss the book on this one, is that some state is going to decide that in the 2021 election cycle that state legislative districts should be apportioned based on citizen population, and because you can't quite prove citizen population, they'll say you can use registered voter population as a surrogate for that. There are already 3 votes on the Supreme Court in support of that position. In Evanwell v. Abbott, Justice Thomas, Justice Alito, and Justice Gorsuch. I think you can expect that that issue will reach the Supreme Court somewhere in the mid-decade coming up, and how it will be decided, anybody knows. But let me point out the consequences of that. The consequences of that is it will shift political power from urban areas to rural areas, much as the geographic gerrymanders that were invalidated in both Westbury and Reynolds against Sim shifted political power and locked it into the rural areas. It will leave the urban areas, which have larger non-citizen populations than the rural areas, with service responsibilities for those people. After all, the 14th Amendment says no person shall be deprived of equal protection of the law. No person shall be deprived of due process of the law. Not no citizen or no registered voter, but no person. So those areas will end up having service responsibilities for people who are residents within their districts, citizen and non-citizen, many of whom are poor, with no political influence, disproportionate underrepresentation in Congress to get their fair share of the revenues. In Evanwell against Abbott, an amicus brief was filed on behalf of a group of mayors, which included, incidentally, Peter Buttigieg when he was mayor of South Bend, in which they made that various point, that they were responsible for the welfare of the citizens in their district, or the people within their district, whether they were citizens or not. And they needed representation in order to carry out that responsibility. So let me finish where I began. The Supreme Court had the perfect opportunity to create a more perfect union. They chose to go in the opposite direction. They have endorsed the constitutionality of partisan gerrymandering. They've given the major political parties a green light to rape, murder, pillage, and burn as far as representation is concerned, and that the only avenue of relief, absent a change in the composition of the court, is in the state courts. There is one other irony which I have to point out. 2 months after the Supreme Court of the United States threw up its hands and said, this is too complicated for federal judges, constitutional partisan gerrymandering is perfectly permissible, a 3-judge state court of elected judges composed of both Democrats and Republicans in North Carolina said, these issues are not that complicated. They are fully justiciable under the First Amendment of the North Carolina Constitution, under the Equal Protection Clause of the North Carolina Constitution, and held unconstitutional. In a case called Common Cause v. Lewis, the partisan gerrymander of the North Carolina General Assembly. And then in October, the same 3-judge panel, in another case, held unconstitutional the partisan gerrymander in North Carolina of the congressional districts, the same gerrymander that was challenged as unconstitutional in Rucho. The irony of that is that in the Rucho opinion, it sounded like a soundbite from the Senate. Chief Justice Roberts said, unelected federal judges should not be making these decisions. Does that sound like the confirmation process in the Senate, in which unelected judges are doing terrible things like Brown v. Board of Education, like other cases, when elected judges in the state of North Carolina were willing to do so? We thought that one of the strengths of the federal judiciary was judicial independence resulting from lifetime terms. That has now been turned on its head to be a reason why the federal courts should not intervene. Thank you very much for allowing me to
Thank you so much, Mr. Bondurant. We have time for about 2 more questions. If anyone wants to ask any questions, we have microphones on both sides of the aisle. Okay then. Oh, sir. Okay, one question.
Yeah, so thank you so much for coming. I want to offer you a particular thank you on behalf of all my fellow constitutional law students who didn't have to go to class this morning and got to instead attend this. But anyways, so I appreciate you coming and talking. And one thing I thought was interesting in your speech was, I guess my question is, we have particular issues, and we all understand that egregious cases of constitutional gerrymandering, like you see the Alma Adams district in North Carolina in the previous map, it was like a snake going from Charlotte, absorbing urban areas. And that was a very particular egregious example. But today, when we have these urban and rural divides in our country that kind of divide partisan lines, there seems to be a particular inclination to assist more conservative districts. How do you solve that without, I guess, making a plebiscite on a state level and apportioning voters based on that? What would be a solution under the law? Thank you.
This is not nearly as complicated as it's made out. It is true that there is a phenomenon called clustering, that birds of a feather gather together. Democrats tend to live in urban areas, more conservative people are in rural areas, and so forth. But that does not mean necessarily that districts should be gerrymandered. What a gerrymander does is take the voting history of voters in little bitty areas called voter tabulation districts and looks at how they vote in statewide elections over time. And the leading gerrymander expert for the Republicans, the late Dr. Thomas Hoffler, used that sort of data. He testified in our trial that voting history data was the most reliable predictor of future voting behavior. Remember that in 1986 in Davis, Justice White had written, it's really difficult to know why people vote the way they do. They can change their minds. It depends on the candidate. It depends on how much money the candidate has, the issues, whether the candidate's had an extramarital affair, a lot of those things, that you can't really do that. Well, Dr. Hoffler and computer technology have proven that to be a myth, that you can use that data. In Rucho, Chief Justice Roberts made the same argument. This is very complicated. He ignored the findings of fact, which were undisputed, never appealed from. Not only Hoffler's expert testimony, but the results. In 2011, Hoffler gerrymandered the districts in North Carolina to achieve a 10-3 advantage. In 2012, a wave Democratic election, he hit 12 out of 13. He missed batting 1,000 by 600 votes in one district. By 2014, he was batting 1,000. In 2016, his stated objective was to achieve and perpetuate the 10-3 partisan advantage. In the 2016 elections, he hit 13 out of 13. In the 2018 elections, another Democratic wave, he still hit 13 out of 13, even though the Democrats took a majority of the statewide vote. In Maryland, in which the Democrats chopped up a single Republican district, that had been a Republican district for over 20 years. The Republican incumbent had been reelected in 2010 by 20 percentage points. In 2012, he was defeated by 20 percentage points. In 2014, the district remained in Democratic hands. In 2016, the district remained in Democratic hands. In 2018, it remained in Democratic hands. So clustering can be a factor, but you can with statistics, as we did in Rucho. We had two wonderful expert witnesses, one of whom ran a mere 1,000 maps that took into account every legitimate redistricting criteria identified by the legislature. You know how many would produce a 10-3 Republican partisan advantage? The number was 0. Another expert, Dr. Mattingly, is head of the math department at Duke, using mathematics that I have never heard of, ran a mere 120,000 maps, from which he culled down to a mere 24,000. And out of those 24,000 maps, you could identify precisely which districts were outside the statistical possibility of being drawn on any kind of neutral principles, and identify which districts fell within the range. And out of that 24,000 maps, less than 0.00% would produce a 10-3 partisan advantage. He has subsequently written an article in which he does a graph in which he graphs the result of this sort of mapping and demonstrate what he calls the signature of partisan gerrymandering. You can see the districts that fall along neutral lines, and you can see the districts that fall outside the parameters beyond any statistical probability that it is the result of chance or any legitimate factors such as democratic clustering. And in North Carolina, I hate to re-argue the case, but I will. The state called an expert who testified about, there's this factor called democratic clustering. And one of the other lawyers in the case, Steve Epstein, said, "That's very interesting, doctor. Let's look at Asheville, one of your maps, which had a democratic cluster, the People's Republic of Asheville, blue. The line went right down the middle of Asheville and submerged that population in two overwhelmingly Republican districts. Well, let's look at Greensboro, home of North Carolina A&T, the largest historically black university in the country. Guess where the line went? On one side of the campus, they were in one district. On another side of the campus, they were in another district, all overwhelmingly Republican. And you went to Charlotte and Mecklenburg County. The same thing. His blue Democratic cluster had a gerrymandered line going down the middle that put everybody in districts in which they were submerged and overwhelmed by the Republican vote. So the idea that this is a natural phenomenon is simply untrue. Yes, it is true that an honest, neutral redistricting system may or may not result in proportional representation. No one has a right to proportional representation, but they do have a right to a fair election system. If you were trying to summarize the Constitution in one sentence, or maybe two, it is that the Constitution contemplates that elections will be partisan, but the Constitution does not contemplate that election procedures will be partisan. There is a difference. Thank you very much.
Before the students leave, I think everyone should know, if you don't already know, because some in the room do not, that Mr. Bondurant argued the Rucho case, both in the District Court of North Carolina and prevailed before the three-judge panel. He argued it, and the three-judge federal court struck down the North Carolina law as unconstitutional gerrymandering, and then he argued the case before the United States Supreme Court. And you also should know he argued his first voting rights case before the United States Supreme Court when he was 28. So I think everybody should know that. Is 28 right, Emmett?
No, it's 26.
26. I just didn't want the students to leave without knowing that background.
All right. Thank you all so much, and thank you so much, Mr. Bondurant, for that very informative speech. We're now going to take a coffee break for about 15 minutes. We will start with panel 1 at 10:40. Thank you.